A perfect time to welcome our guest for this hour, trial attorney Michael Jaafar. And what do you think, Michael? Do you think that this is a strong defense witness?
I think he's a very strong defense witness, and I see the differentiation between, for example, a personal injury context where you take responsibility for whatever happens to a person that you are choking out, or a criminal case where you have to prove scienter, you have to prove, some sort of malice, some sort of an intent. I know he's being charged with reckless, but even recklessness requires him to be reckless, right? And so if the person had if the person choking him exercised due care and caution and did it the way he's supposed to do it, but the person that he did it to, suffered an unreasonably high amount of physical damage from it, I could see a jury not saying that he was guilty beyond a reasonable doubt of all the elements of the crime.
It's a really great point. We are seeing more and more defendants take the stand. Do you agree, Michael? It could be because of the social media aspect, and we have videos in these. Go ahead.
I was shaking my head. It was so refreshing to see my co-panelists just say that. I say it all the time that we are not in the O.J. Simpson era where you could sequester a jury and you could just keep them hidden from the facts and from the media. It's a completely different society. What she just said, I think every single criminal defense attorney should understand when they take cases, that it's different. Your jury is going to be on social media just themselves, and then their friends and family are going to send them snippets and clips, and they're not going to get the whole story. I completely agree with that. In this day and age, if you sit at counsel table and you don't go on the defendant's witness stand and cry and talk about your story, your defense, you're doing yourself a disservice.
So if Young Thug's at the middle of a wheel, you have the spokes of the wheel, the evidence to connect to all of these crimes. So then let's turn, Michael, to the lyrics, because is it freedom of speech, or do you think rather that it's admitting criminal activity that can be used to convict him?
I believe that the judge made the right decision. I believe that you should be able to use somebody's lyrics. Remember, the judge said as long as they pass the foundational test and the relevancy test, they can be admitted. They cannot just simply admit willy-nilly any lyric. That would not be fair, and nor is that what the judge said. So as long as it passes the relevancy and the foundational test, according to the judge, it can be admitted, and I agree. I think it's fair game. One of the co-defendants has already said that this specific lyric here mentioned me and mentioned a crime I did. So it actually is very relevant, and as long as it passes the foundational relevancy test, I believe it's fair for the prosecution to be able to bring it in. Now, the defense could come in and say, hey, this was admitted, but it didn't mean what the prosecution said. So it's not exactly a game-changing piece of evidence, but it's helpful for the prosecution for sure.
And I do think it is good evidence for the jury, meaning that the jury hearing it, I think, is really going to be compelling to think about, okay, is he admitting to the criminal activity that's alleged?